Okay, so good. Well, that speech by and discussion by Leo Strine obviously reflects a lot of passion that he feels about this issue. Um, the panel discussion that we're going to have now is about a law case that deals with, in a very important way, the climate change issue, although not directly in the case. The case is McRitchie versus Zuckerberg. And I'm going to introduce the panelists, and they're going to speak in this order, and I have a few things to say myself. But so the panelists here are Rick Alexander, who is sort of an instigator of this story, the CEO of Shareholder Commons, an NGO that describes themselves as addressing social and environmental issues from the perspectives of shareholders who diversify their investments to optimize risk and return. And so you'll see how that plays in the litigation that he initiated. But before taking on this role with starting really an NGO that's played a very important role in these debates, Rick was sort of a real lawyer, a lawyer at maybe the leading Delaware firm, where he was the managing partner of the firm for 4 years, and then became head of the B Lab, which was a pioneer in the development of the benefit corporation. And so he really is a godfather of many of the most important developments in the field. Second speaker is Amanda Rose, who has a distinguished chair at Vanderbilt Law School, who's an influential scholar in these matters, and has written an article which is relevant to today, a hard look at portfolio-focused stewardship as a rationale for SEC mandated ESG. I'm then gonna, after that, offer a few words, and finally, Roberto Calarita, who's joining our ranks in the scholarly field, assistant professor at Harvard, who's already an important person in these debates, has written on portfolio theory himself, fiduciary deadlock, which takes on some of the questions that Rick himself has pushed about how portfolio theory and portfolio ownership engages with hard issues of fiduciary duty. So let me just say a couple words about the case. That's going to be the focus of today's panel, the McRitchie case. So in this case, the plaintiff alleged that Meta followed through with strategies that generated large social externalities through really the manipulation of the algorithms, the Instagram, Facebook, the point of which was to maximize the engagement of various groups, sensitive groups like teenage girls, and were indifferent to or exacerbated the level of misinformation, toxicity, and violence in the posts. So those are the harms. And in the litigation, the plaintiff further claimed that the strategies benefited the concentrating, controlling owners of Meta stock, Zuckerberg being one of them and other directors. So the concentrated owners were benefit at the expense of the diversifieds, who in fact held the largest percentage of the cash flows, but but nevertheless were diversified in that their investment in Meta was just a fraction of their portfolio holdings. So the argument here, the allegation was that the pursuit by Meta of the strategies that increase the value of the concentrated owners was a violation of the director's fiduciary duties to the majority shareholders who were in fact portfolio investors and therefore suffered disproportionate harm. And then there was a particular cleverness, I thought, in the complaint, in that the strategy put forth by the defendants needed to be addressed through the demanding lens of entire fairness, not just the BJR, the business judgment rule, because the defendants' concentrated ownership created a conflict of interest. So in their efforts to maximize the Meta stock price, they favored their personal pecuniary advantage at the expense of the shareholder majority who were portfolio investors. That's kind of a nice twist in the legal standard. Well, the punchline of the case is that the plaintiff lost, the defendants won. And the story of that case, the reasoning of the court, the implications, the ongoing debate, that's what this panel is going to discuss. So with that, we'll turn it over to Rick, who will start us off.
Thanks, Jeff, for that introduction. Never been called a godfather before. Actually, I want to point out that in the audience today is Steve Leidenberg, who is a true godfather of the universal ownership movement. And I knew nothing about any of the issues that Jeff just talked about. And when I started studying them, his work was some of the primary stuff that I read. So I'm nervous to be talking in front of him. So what I wanted to do, I think it would be challenging to really go through like all the reasoning in this case. And I'd love to do that sometime, but I don't think today we're able to do it. I'd love to see some academic work done, and I'd love to talk to somebody about doing some work to really talk about the bones of that case. So if anybody's interested, please let me know. But what I wanted to do today was really just talk a little bit about the thinking that went into our theory of the case, and then why we're not so disappointed with where the case came out, why we think the ball was somewhat moved forward. And I also want to comment that today has been so interesting to sort of from the perspective of this case, because a lot of the discussion, I think, on the panel so far has sort of been, well, if you're a fiduciary and you're supposed to maximize value for the benefit of shareholders, how can we talk about climate in a way that will maximize the benefit of the individual company? And I think there's a little bit of a square peg and a round hole there, because, you know, the way our economy works, whether we like it or not right now, is that we reward success in business by measuring the unit of success at the company level. And the fact is that companies externalize a lot of costs. And so until we sort of get out of that mindset, it's going to be very hard to stop rewarding the externalization of costs, including lots and lots of carbon emission. And I think thinking about this in terms of the fiduciary duties of directors is a good way to move forward. And so quickly to sort of launch into, you know, our theory of the case, we start with sort of accepting we're not, you know, and I think some people have alluded, there's a line of thinking out there that you don't have to maximize value at companies, but I think most people accept who operate in Delaware that the job of directors is to maximize the economic value of a company, which kind of means the enterprise value or the discounted value of all future cash flows. But key, and you see I highlighted, for the benefit of shareholders. And what we wanted to explore in this case is whether for the benefit of shareholders meant more maybe than people have focused on so far. And we start in thinking about this by saying, well, why is it that we say that the job of a director is to maximize the company for the value of the company for the benefit of shareholders? And really this goes back about 100 years. The corporate law scholars in here, so we all talk about Burleigh and Means. And the idea is that by setting up a fiduciary duty that way, we could have an economy where we allocate, where we were able to agglomerate lots of resources at single companies and have professional managers run them, because this would give investors confidence that they could do that they could sort of give their property over and it wouldn't be used for the wrong purposes. So that's kind of the core of how we got to having that fiduciary duty. But I also want to say that there's a second reason that maybe we don't talk about so much as a fiduciary reason, but I think it just lines up with the way we think about a market economy, which is that if these firms are maximizing value, that's kind of the Adam Smith idea, right? You are, taking resources and then putting your magic into them, whether it's efficiency or innovation or just darn hard work, you're making them more valuable and selling them at a profit. And so that profit is creating value for society. So I think those are really the two key reasons that motivate this idea of maximizing value. And so what we want to explore in this case is, well, does that really mean that you should always make as much money as possible? And if that means burning a lot of dirty fuel, that you should burn a lot of dirty fuel, or maybe there's a little room to think differently. So we start with this idea that not every time, but more often than not, when cases talk about maximizing value, they say it's for the benefit of shareholders. And we looked at a few examples, like taxes. Like, we know that a board of directors could say, well, we're not going to get the most money for some asset. We're not going to get $5 for an asset if it creates a 50% tax for our shareholders, if we could get $4.90 for the asset and have no taxable event, because the shareholders are going to be better off. So you can see there that for the maximizing the value of the company for the benefit of shareholders allows you a little wiggle room. There's another case that, this is kind of a technical point, but in the limited partnership area, there's this idea of high splits. Sometimes when a company has made a lot of money, the limited partners get less of the next dollar and more goes to the sponsor of the transaction, the general partner. And there's a case that recognizes that when you're in these high splits, maybe doing a deal that delivers like a high return to the company isn't so good for the limited partners, to whom a fiduciary duty might be owed, because they don't get much of it. So again, a recognition that maximizing value, there it was being fair to the corporation, isn't necessarily the best thing for the shareholders. And the really important one that we'll get into is there's a pretty well-known case. It's sort of the genesis of the modern business rule, Joy v. North, Ralph Winter case, not Delaware, Second Circuit, but he says one of the reasons we give such discretion to directors, one of the reasons we have the business judgment rule, is because it allows directors to take lots of risks. And risks are good for most shareholders because most shareholders are diversified in the modern world. And the non-diversified shareholders, they can take care of themselves. So a recognition that the board of directors can make decisions that take into account certain aspects of the shareholders, even if they're maybe not maximizing the risk return from the perspective of a single company shareholder. Jeff talked about the Facebook whistleblower event, so I'll go over this slide. So we take that and we go into this case and we say to the court, look, we think that maximizing value for the benefit of the Facebook shareholders doesn't mean making as much money as possible if the way you did that puts at risk certain economic systems that support the diversified portfolios of your shareholders, most shareholders, many shareholders. And like, we start with modern portfolio theory. It used to be that if you were a fiduciary, if you were like the New York controller and you were holding assets for others, you couldn't even buy equity, even though equity has the highest return, because it was considered too risky. And then some PhD economists came along and they said, if you buy enough of those equities, you diversify away the idiosyncratic risk, but you keep the high returns of equity. It's a true free lunch. And after that sort of caught on, it got to the point where fiduciaries, pension funds, sovereign wealth funds, endowments could buy equities and they could make more money. And that was a really good thing. But it tells you that diversification is intrinsically linked to owning equities. And once you're diversified, the return you get, like if you hire an asset manager to pick stocks for you, only a little sliver of your return is determined by which stock that manager picks. Most of your return, 75% or more, is going to be determined by how the economy performs. So what you really care about as a diversified shareholder is the economy. And then what we talked about in our brief was how there's a chain of value that goes from the systemic impact the corporation you own is having to economic impact, how GDP performs. That is one-to-one correlated, with adjustments, but the economic model would say that's one-to-one correlated with how the market performs. So if there's a 3%, impact on GDP of an externality, that's going to have a 3% impact over time on how your portfolio performs. So that's a sort of the direct chain of impact, why a diversified shareholder might care. So what we said in the brief then was, I'll just read this. While fiduciaries have a general obligation to maximize financial value, that obligation ends when it's opposed to shareholder interests. That's the for the benefit point. Accordingly, defendants, the directors of Meta, cannot refuse to consider whether increases in Meta's financial value came from the pockets of the typical Meta shareholder through harm to their investments. And the court said, nice try, we don't agree. And so, and again, like, I'd love to stand here for a half hour and go through all the points of where we disagree with the court, but I think that's for another day. Suffice it to say, the judge went through sort of a history of corporate law and said he didn't see it. And he also said he wasn't persuaded sort of by our policy argument about impact. But I want to read the second part of our brief, because I think the result of this isn't just that you couldn't force a director to think about this. It's it takes away from the director's toolkit if the case is right, because it means directors who just wanted to think about that, who said, hey, I noticed most of our shareholders are diversified. I noticed our contribution to climate change is really harming them. So we're going to, ease up on this, ease up on our lobbying, like Chief Justice Strine suggested. They could be penalized for that. And that's really unusual in Delaware, where you try to give directors the benefit of the business judgment rule and to use their discretion to decide what's best for shareholders. And so what I want to end by doing is walk through a couple slides to show that I don't think the case is as bad as people might make it out to be. I think it's advanced the ball. And I can also talk to people tactically if they want to know about why we didn't appeal the case in this particular instance. But I think one thing to note is that the court said, he said our argument was a caricature. He said, according to plaintiff, a single firm orientation means fiduciaries cannot consider the cost of their decisions to typical stockholder portfolios. Well, that is what we said. And he says, that's not true. And he called it a caricature. Now, I think if you stop there and say, well, that's the opposite of your holding, because you later said we couldn't do that. But then he goes on to explain. He says, well, directors can consider these externalities and the cost to portfolios, because if you're having a lot of cost to portfolios, you're going to be a pariah. And I think I call it a loophole, but like you can see that's kind of a way he's sort of painting the way. Well, here's how you can care about externalities and portfolio effects. Say you think they're going to come back on you. And then I wanted to just point out that he quoted Professor Gordon's article, and I think he quoted it in a very affirming way that kind of made this point, because he says, Professor Gordon argues because we cited this case as supporting our position. He says, well, Professor Gordon is saying that investors should exercise their stockholder level rights on a portfolio basis, but he's not saying, he does not contend that director fiduciary duties flow toward the diversified investors or that they should. He only argues that institutional investors should use their rights to encourage directors to act and I think this is key, as if they were. And that the business judgment rule gives the directors flexibility to do so. So you can see there's kind of like, well, with a nod, wink, wink, we can get to where McRitchie was arguing to get anyway. And so I think, this case has actually kind of painted the way, a picture of how to get to where we want to get. I'm not satisfied by that, because I think we should be able to talk openly about this. And it's better to sort of understand the threat of externalities and talk honestly about them. And to be able to say institutional shareholders, diversified shareholders, have a different interest than a concentrated CEO does. And that's not a crime, but it's a state of affairs that we need to be able to deal with. And so last slide here, and I also think this is very helpful in sort of a different kind of way. In the holding, the court said, so what I'm saying is, when you all pointed out all the case law that said you have to maximize value for the benefit of shareholders, the duty really runs to the shares, not the shareholders. Stockholders enter the mix only because shares have owners. The fact that shares are alienable means that from the director's standpoint, the ultimate human beneficiaries of that value are incidental. Now, if that's the law, that we run corporations, but the humans who own them are incidental, then we know we need to fix something.
I don't have slides, but I'll stand up since everyone else has been standing up. It's a pleasure to be here. I wanted to start by talking a little bit about the court's reasoning, not the doctrinal analysis, which rejected the plaintiff's position in the case, but the court's rationale as to why the law shouldn't be changed to adopt the position that Rick advocated for. In part, the court's rationale was, well, I can't change Delaware Supreme Court precedent, which I've interpreted in this way. That's up to the Delaware Supreme Court or the General Assembly to do. But beyond that, the court also went on to indicate its belief that Delaware corporate law shouldn't be changed because it would be a poor vehicle for achieving the goals that Rick wants to achieve, and that state corporate law generally is poorly positioned to do so. So in the court's view, the sort of traditional approach is the better one, the approach where laws external to corporate law deal with externalities, whether it be environmental regulation or tort law or labor law. And corporate law plays a much more limited kind of backstop role with respect to externality regulation insofar as it holds that directors can't knowingly and officers can't knowingly violate other positive law consistent with their duty of loyalty. And the court makes the point that it would be difficult for Delaware corporate law to really do more than that. Why would it be difficult? Well, the court points out, and this is a theme that's come up in the panels previously, that Delaware is just one of 50 states that offers corporate law to corporations. Corporations have to choose to incorporate in Delaware law. To incorporate under Delaware law. And the court emphasizes that Delaware has been so successful in attracting corporations to the state because it has taken a technical, nonpartisan, enabling approach to corporate law and has avoided sort of wading in on hot button societal issues. And the court asserts that, we're the General Assembly to change the law and adopt Rick's position that companies might leave and sort of opt out of the regime, meaning it wouldn't be a very kind of stable or durable solution to the corporate externality problem. The court also notes that Delaware law is flexible enough to allow companies to adopt this approach, to adopt a diversified investor model where fiduciary duties are understood sort of in the way that Rick advocates for through modifications to the charter or by becoming a public benefit corporation. And so the court thought we don't need to go out of our way to kind of change the traditional understanding of common law fiduciary duties to achieve that in light of those opportunities. So that's the court's sort of rationale. I wanted to make just a few points related to that reasoning before turning the baton over to the next panelist. And I wanted to start by saying that I agree with the court that corporate law is a poor vehicle for addressing the very real problem of corporate externalities. In part, it's a poor vehicle because of the reason that the court emphasizes that companies can opt out if they are unhappy with that approach. We've been reminded recently that companies can change their mind and leave Delaware if they want to. But I think it's a poor vehicle for some other reasons as well, and I wanted to highlight what those reasons are. First of all, it's not just the case that corporations are mobile in the sense that they can change states of incorporation. Capital is also mobile. And even if externalizing companies chose to stay in Delaware, if their managers manage the companies in the way that Rick advocates for by sacrificing firm profits for the benefit of the broader economy, that's going to create an opportunity for investors who are more concentrated to take over the company, change the focus to a single firm focus and profit. And so for that reason as well, I think it's not a very stable solution to the externality problem. Now, we could fix that by somehow changing the law to prevent investors from taking concentrated positions in companies, but that'd be a pretty radical departure from the norm in kind of a capitalist free market society and would have other kind of negative follow-on effects. So that's just like a reality that I think makes the theory problematic. But I want to set aside those two issues that make it just like not very stable or enduring potentially, and talk about a couple of other reasons why I think that the court reached the right decision or why we might be skeptical of the theory that was advanced. The first has to do with managerial agency costs. So whatever fiduciary duty law tells directors they should focus on and prioritize and put first in their decision making, it's possible that corporate managers will instead put themselves first. This is the perennial problem of managerial agency costs. And I think that reconceptualizing fiduciary duties and the way that Rick advocates for would cause firms to abandon one of the best techniques that exists for mitigating managerial agency costs, and that is stock-based incentive compensation. So Rick sees stock-based incentive compensation as part of the problem because it incentivizes firm managers to externalize to the extent that they can to boost firm profits. And of course, that is an incentive that stock-based compensation creates and any kind of firm-focused incentive creates. But let's not forget that stock-based incentive compensation exists not just as a problem, but as a solution to another problem, and that is the problem of managerial agency costs. It's one of the best techniques for aligning the interests of managers with the interests of shareholders and working hard and working faithfully to operate the business well. And abandoning that, which would be a natural consequence of Rick's theory, I think would be problematic. Why would companies abandon it? Well, because his whole theory is that having concentrated positions in the firm is what creates a conflict of interest, which then subjects managerial decisions to entire fairness review, which strips them of the right to rely on the business judgment rule. And so in that world, you wouldn't want to have heavy concentration in your own firm's stock. And I think that that could lead to losses in portfolio value writ large. So even diversified investors might find the single firm focus buttressed by stock-based compensation to be a better instrument for maximizing portfolio value. Not because they care more about the performance of any given firm. Obviously, they care about the performance of their broader portfolio, but because a single firm focus is a better mechanism for dealing with managerial agency costs. My last point is one that assumes away managerial agency costs, okay? I think that's a big problem and something we should talk about. But let's assume that corporate managers are faithful. They're going to try really hard to do whatever Delaware fiduciary duty law tells them they should try to do. I still think it's a bad idea, Rick's theory. And I want us to really think about what's being advocated for. So the thought is that we want fiduciary duty law to direct corporate managers to manage companies in a way that maximizes the value of the economy as a whole, even if it requires sacrificing profits at the firm level. Now, that sounds really nice, especially if we assume on faithful fiduciaries, right? But how exactly are corporate managers going to decide how to manage the firm to maximize the value of the economy as a whole? I suspect that Rick has some ideas for how companies should, what kind of decisions they should make, what kind of policies they should implement to maximize the value of the economy as a whole. And I suspect that maybe a lot of people at this conference might agree with his views on that, but there's a whole lot of people that are going to disagree that that is the right choice that companies should make to maximize the value of the economy as a whole. The reality is that figuring out what is in the best interest of the economy as a whole is very hard, and it involves decisions that are going to be based on trade-offs of competing values, decisions that are made in a world of imperfect information and uncertainty. The question really is, do we think that diversified investors who are going to have heterogeneous political preferences really want to entrust corporate managers with responsibility for making those sort of high-level decisions? I don't think so. I think that the political realm is the proper realm for contested choices of that nature to be debated and resolved in a democracy. Now, if the political realm is dysfunctional, then I think we should focus our energy on fixing the dysfunction, whether that be through efforts by asset managers to alter political spending by corporations, as was just discussed, or otherwise. That should be the focus instead of sort of kind of giving up and shifting responsibility to corporate managers to do things that I don't think corporate managers have really the capacity or the legitimacy to do. So in short, I agree that diversified investors care about portfolio value, but I think there's a lot of reasons why they might prefer the status quo as sort of the best system that we have to achieve those ends. Thanks.
So, slides? Yeah,
He's talking about.
no, I have slides.
You have slides?
Yeah, the continuation of my slides. Okay, all right, so can I see my screen? Whoops. Right. So. So they thought my slides were only for the panelists, but actually I've got, there's more to, why isn't this working here? Am I not getting, how do I resume my slideshow? Okay, all right, okay. Okay, so I'm going to offer an assessment of the case that maybe has a somewhat different perspective than both Rick's and Amanda's. First, the doctrinal endpoint, and then the second, the route by which the court got to its result. So as a doctrinal matter, I think that the McRitchie court is plainly right. The board can't be compelled as a matter of Delaware fiduciary duty law to take account of the interests of the diversifieds in the management of the firm, particularly as regards the externalities and even patently obvious systemic externalities such as climate change. And that's because I don't think the board can be compelled as a matter of fiduciary duty law to take account of the interests of any of the shareholder groups within the firm. The directors are in some broad sense accountable to those shareholders within the firm, but that accountability is really expressed through elections, not the idea that they can be compelled through judicial means to take account of one or the other groups in a case in which there's no self-dealing. This is just how we conduct the business of the firm. So I think that's the doctrinal conclusion of the case, and I think that's at least I don't disagree with it. But I also think there's no doubt that the firm can seek to avoid externalities, including the systemic externalities that the diversifieds will be keenest to avoid. Because I think that Delaware fiduciary duty law does not require profit maximization at the cost of what the board determines are the externalities that it wants to avoid. And it is simply not the case that, to pick the sort of an easy case, the board is not I mean, if you have two choices as to deal with a plant that addresses the effluents, the runoffs of production, it's simply not a matter of fiduciary duty that the board has to pick the lowest cost way to filter the effluents, even though the consequence would be considerable downstream harm, just because the way that reduces that harm is it costs more. And it's the poor board that can't figure out a way to frame that choice in some sort of way that's consistent with the long-term value of the firm anyway. But the practical effect is that the firm is not obliged to ignore the externalities of the production. And I think in a more general way, the board has the freedom of the BJR, certainly framed in terms of the long-term and the short-term, to take account of the pecuniary and non-pecuniary interests of the actual shareholders in the firm. Now, B.C. Laster frames his decision in terms of a single firm focus. That in this, and so he gets to this result by saying that the board cannot be compelled to act on behalf of the diversifieds, the portfolio investors, because its duty must be to the firm itself, not to any particular group of the shareholders. Rick said in his initial setup that they essentially focused on the fact that the duty of the board is to the entity and to the shareholders of the entity, and therefore, if the shareholders are diversifieds, the board has a duty to attend to the diversifieds. Laster counters that by saying the board's duty is to the firm itself, which he describes as a single firm focus. As though that solves the hard questions here. There's rhetoric in Delaware that frames it in that way, a single firm way. You can find cases, but that's not functionally accurate. That is not how boards behave. So think about a firm that's got that has controllers. That is a controlled firm. The board will pay attention to the interests of the controllers. When it comes to the timing of dividends or repurchases, they will pay a lot of attention to the controller's liquidity needs. And there's a famous case to that effect of the Sinclair Oil versus Levian case, which validates the board's behaving in that way, even though the plain effect of the dividend payout was to advantage the controllers who wanted liquidity for some investments and disadvantage the other shareholders of the firm who might have wanted the cash available for their subsidiary to invest in its own potential. So where there's a conflict between the controllers and the public shareholders, so long as there isn't sort of a blatant payout, a disproportionate payout to the controllers, then the transaction itself will be reviewed under the BJR. And nobody blinks at the idea that, you know, in a control firm, the board will select a CEO who happens to be part of the family that controls the firm, or a CFO, without exactly running a tournament to figure out who would be in fact the best CEO for that firm at that time. So we already accept the idea that in a controlled firm, the board is perfectly consistent with their fiduciary duty to pay attention to the dominant shareholders of that firm without focusing in an exclusive way on whether that's best from a single firm focus. So, and the claim is, or the observation is, in a non-control firm, key decisions are commonly made precisely because most of the shareholders are portfolio investors. And we see this all the time. So think about the forms of governance. Firms typically adopt governance, single class board, annual say on pay, board committee, dual CEO, board chair or lead director, because the fully diversified shareholders, the asset managers who own these shares, regard these as the best way to do governance across their portfolio. They don't have time to tailor specific governance to a single firm, and the board which decides that for this firm, a staggered board is best, nevertheless is going to go along with the portfolio shareholder view because that's just who the owners are, and they want to, and to that extent, they're prepared to exceed in a single firm way. To exceed what the dominant owners prefer, even though in some other way, from a single firm focus, they would be resistant. A sort of a more important way in which this is the case is the strategy of the firm. So ever since the breakup of the conglomerate experiment of the 60s by the takeover wave of the 80s, it has been understood that investors strongly prefer to diversify at the portfolio level, not at the firm level. And that has been a fundamental guide as to how all firms structure themselves. So even though you might think that from a firm-specific perspective, an own firm perspective, the way to minimize the risk associated with that firm is firm-level diversification. In effect, the insistence of the portfolio investors means that firms will focus, that they will not engage in unrelated diversification, and that the shareholders who hold their shares in a portfolio, they have neutrality when it comes to risk. They're not risk averse in the way that the CEO of a single firm might be, or the undiversified of a single firm might be. So already in the most important ways, the boards accede to the strategies preferred by the portfolio investors. And it's so obvious that we barely talk about it. So how is that consistent with a single firm focus that Laster would suggest ought to be the guide? And indeed, we see this all the time because an activist commonly will go after a firm with conglomerate entities, and they'll have the support of the portfolio investors to require spinoffs. And in expectation of such actions, We see business strategy behavior in which, again, unrelated diversification is disfavored and maybe related diversification is okay, but that is precisely because of the importance of the portfolio investors and the way that firms are trying to accommodate themselves to what the portfolio investors think is best. And the portfolio investors are not kibitzers here because their votes are critical to what the activists can do and thus how these firms are structured. And say on pay is a similar thing, right? The portfolio investors want compensation patterns, the goal of which is to lead managers to take firm-specific risks, which increase the failure rate, because taking those risks will increase the value of the portfolio as a whole. So at one level, the importance of portfolio investors to how US firms are run is straightforward, obvious, and really important. So my restatement of the doctrine is there's no such thing as a single firm focus. Rather, it's a single firm focus constrained by awareness that the majoritarian shareholders in most firms are portfolio investors, and their interests are best served by a strategy that in significant respects takes that fact into account. But here's the point. The title of the slide, compulsion no, opportunity yes, in the Delaware law of externalities. So the board has flexibility here, but it cannot be compelled. A board may, shielded by the BJR, take account of the interests and desires of the dominant portfolio investors in a strategy. But the point I want to make, the critical point, is that this director discretion is subject to the legitimating acquiescence of the shareholders. And that is really important because that's where Amanda's caveat comes in, which is to say, if the directors pursue a strategy of externality avoidance, to put it that way, that trades off too large a share of the enterprise earnings, then the result might be a shareholder revolt. So that will place in a very real way constraints, I think, on what the directors can do. Because in the end, it has to be it has to be a level of trade-off, if you want to put it that way, that achieves its legitimacy by the very fact that the directors can be ousted. And that's why I have, in other settings, written so much against the effort to use a poison pill to block what the activists might do, is because it is the very fact that the shareholders, that the directors are exposed, that gives them the legitimacy to think in terms of the trade-offs here. There's a following point, which again, I think has been alluded to earlier, which is to say that the firms, that the controllers, that the shareholders that don't like the Delaware solution on board power responsibility to deal with the externalities like climate change have an exit option. And this, of course, is going to place a limit, as has been discussed, on the ability of boards at a single firm to really accomplish that much that's outside a certain level of consensus. Part of the reason that Laster is so opposed, I think, to the idea of an injunction requiring the boards to take account of the purported interests of the portfolio shareholders is because it's asking of a court asking of Delaware law, too much to obtain a important social goal through the mechanism of a compulsory adherence to a particular duty of fiduciary, a particular vision of fiduciary duty. And that, he says, Delaware just doesn't have the power to do. I mean, we've seen it just, in the recent times, right? The TripAdvisor case and the pushback that controllers have had against different features of Delaware and the concern about exits illustrate all too well his caution, which is to say, I mean, the paragraph that I quoted here, it is frankly difficult for Delaware to use corporate law to do more. Reformers who look to Delaware to address the externalities must acknowledge the larger political environment. Delaware is one of 50 states that can offer entities embodying different corporate law packages. And it, at the end of the opinion, Laster goes on to note that Delaware just doesn't have the market power to use judicially determined ideas of fiduciary duty to compel pro-social behavior. In a sense, state law may not be able to do that in any event, so long as there's the right to exit and set up elsewhere. So the Delaware law, as I see it, gives the opportunity for boards to take action on, say, the climate change dimension or other externalities. But first, the legitimation of directors to do that is also exposure to the shareholders who might disagree. And second, there's a limitation as well that derives from the fact that there are competitive alternatives to Delaware as a state of organization. And I think the judge is sensitive to that. As he says, we need to pick the right tool for the job we have in mind. So, Roberto, you are next.
All right. I have some slides too. It's called shrimps. We'll find out in a minute why. Yeah, I hope so. You have to. No. Here. And you have to click the thingy. Here. Yeah, presentation. Okay, thank you. I've heard many interesting things from my co-panelists, many interesting reflections, but I want to use my few minutes, and will be few, not like Leo's few, to talk about a slightly different thing. I'll take a different angle, and I'll talk about shrimp salad. Now, you understand you might be puzzled, especially after many hours listening to various arguments on climate and corporate law and fiduciary duties. But if you bear with me 3 minutes, I promise I can explain. So my story starts with this man, John Chipman Gray, prominent scholar of corporate law, of property law mostly, professor at Harvard Law School, so presumably a wise person, co-founder of the law firm that a few decades would become Robson Gray. John Chipman Gray was also a scholar of jurisprudence, of legal theory. He was very much interested in the question of what we mean when we talk about rights and duties. And since in today's colloquium is all about duties, fiduciary duties, duties of directors to do this or that. He would be very much interested in what we're talking about here today. His most famous work was a book titled The Nature and Sources of the Law, very broad title. In 1909, you could get away with this kind of very ambitious titles. In this book, precisely in page 20, shrimp salads appears. So Gray is reflecting here on the meaning of rights and duties, okay? Remember, so he offers this example. The eating of shrimp salad is an interest of mine, and if I can pay for it, the law will protect that interest, Gray's writes. Therefore, it is a right of mine to eat shrimp salad, which I've paid for, although I know the shrimp salad always gives me the colic. So the reason we care about the shrimp salad story, or I care at least, is because one of Gray's students at Harvard, a few years later, took issue with his example. And the student was Wesley Ofeld, a giant of legal theory in the early 20th century. After graduating from Harvard, and he worked a little bit with Gray in his law firm, and then he got a tenure-track job at Stanford. Then he moved to Yale, where he wrote a very famous article about theory of legal relations, theory of rights, which is to this day, more than 100 years later, and I quote a prominent legal philosopher, the most widely accepted analysis of the logical structure of rights. So why Hofeld didn't like Gray's shrimp salad story? So the reason is that Hofeld makes a very important distinction in his vocabulary, in his theory, between rights and privileges, okay? So a right for Hofeld is an entitlement which goes together with another person's duty, okay? So if A has the right that B pays her $100 by next Tuesday, it logically follows that B has the duty to pay A $100, okay? Rights and duties necessarily go together. This is what Hofeld said. By contrast, a privilege is a different kind of thing, is a different legal concept, is an entitlement that goes together with someone else's absence of rights, what Hofeld calls a no right. So if A has the privilege of entering Wiseacre, it means that other people, B, C, D, have no right to prevent A from entering Wiseacre. So rights and privileges are two very different things, Hofeld says. And in the shrimp salad story, which Gray characterizes as a right to eat the shrimp salad, Hofeld said, no, this is not a right, this is a privilege. I mean, typically, okay, if Gray paid for his shrimp salads, he would typically have a privilege and also rights against interference from third parties with his eating the salads. Otherwise, if it's, it would be a tort for some other person to prevent Gray from eating the salads. But it's not a logical implication, Hofeld says, of Gray's privilege to eat the salads that Gray also has a right against interference, okay? So he writes, oh, yes, this is the illustration. So Gray, he writes basically, what if the owner of the shrimp salad tells Gray, eat the salad if you can, you have my permission, my license, I'm the owner of the salad, I'm giving you permission to eat the salad if you can, but I'm not promising to try to stop you, okay? So Gray has a privilege, Hofeld says, but he has not the right that the other person shall not interfere. Now, Why am I talking about this? You're wondering. Because I think that the shrimp salad problem is precisely the problem that we are talking about here in the post-McRitchie world. In other words, we have a Zuckerberg shrimp salad problem. Full disclaimer, this is an AI-generated image. I have no evidence that Zuckerberg has ever tried to eat a shrimp salad or even likes it. So what did the plaintiff, Rick and his co-conspirators argued? That corporate fiduciaries have a duty to choose the business option that reduces negative externalities, even at the expense of the company's value, if those negative externalities hurt the value of a well-diversified equity portfolio. And what did VC Lester say? That there is no such duty. Now, Hoffel tells us that if A has no duty to choose X, okay, it means that A has a privilege to choose X. A privilege is the negation of a duty in his system. So we are back to the shrimp salad problem, where Zuckerberg has no duty to choose the socially responsible option, the salad here, but he has the privilege to do so. This is what Professor Gordon astutely argued a minute ago, saying no compulsion but opportunity, which Hoffel would call a privilege. But let me offer 3 wrinkles that complicate this picture. So wrinkle number 1, do directors have a true privilege, a real privilege, to choose the socially responsible option? Sure, they have a privilege against the broadly diversified or maximally diversified shareholders, or maybe shareholders in general. But they also have, and this is pretty clear in the McRitchie's opinion, they also have a duty to act in the interests at the firm level to maximize the value of shareholders. It's true that we say, and Jeff said, and many people today have said, that there is the business judgment rule, et cetera, that in practice, this duty is fully operative only in narrow circumstances, but it's there nonetheless. And I think also this raises a question of transparency in our advocacy and in our discussion. I think it's a kind of, it's not the best way to argue for corporations' role in climate risk reducing actions to hide ourselves behind the standard of review or evidentiary difficulties. The duty to maximize shareholder value is there. So even if it coexists with a privilege, it is a real duty when the socially responsible option is in conflict with the value maximizing option. This is the first question which I think we should talk about. Second wrinkle is this. So let's suppose that the directors have a true full privilege to eat the salad, to choose the climate-friendly option. We still have a big problem, right? As you see from this illustration. So let's go back to Hoffel's game. Gray has the privilege to eat the salads, but the owner of the salads has challenged Gray to say, well, try to eat the salad, we'll see. You have a privilege, but you don't have a right against non-interference. What does this mean for the public corporation? Maybe corporate fiduciaries do have the privilege to choose the socially responsible option, but they don't have a right with respect to this option. If shareholders do not like the option, they're free to interfere. They can vote against executive compensation, they can even fire them, they can agitate. So just like the owner of the salad in Hoffel's example, shareholders are free to interfere, and therefore the effectiveness of the privilege is ultimately premised, and it ultimately depends on a number of other factors. And so how do we take care of interfering shareholders? This is a question that has not been discussed much today. Should we limit their power to hire fire managers? Should we have director elections every 5 years instead of every 1 year? Some advocates of stakeholder governance have proposed this. And is it worth it? Is the cost of this worth whatever benefits we could get from this reform? I think we should be explicit about this because this problem requires a solution. Third wrinkle is, well, let's suppose that we solve this problem. Let's suppose that Rick and Jeff and Madison are right, that many shareholders are actually sufficiently care about negative externalities that they will not really interfere with managers. Okay, I'm more pessimistic than they are about this, and I wrote about it. But let's grant that they are sufficiently diversified and sufficiently incentivized to care about the value of the economy as a whole, to decide not to interfere with the eating of the salad. Now, the CEO has a true privilege in this case, unconstrained by the threat of interference. But now what? The CEO has a shrimp salad in front of her. Nobody will interfere. Will she eat it? Why? Why do we expect CEOs to do the socially right thing? I mean, remember the very first thing John Chipman Gray said in his story: the eating of shrimp salad is an interest of mine. And he explained that this is a crucial element. Gray wanted to eat the salad. Eating the salad was an interest of his, something he desired. But do CEO want to choose the climate-friendly option? Why? We need a motivational theory. We need a theory of what drives corporate leaders to make socially responsible choices. I haven't seen much of that in the literature. We need to talk about psychology and sociology of corporate leadership and why, in the absence of interference, so in the presence of a true privilege, we would expect a CEO to choose to do the right thing, to choose the climate-friendly and socially responsible option. So the shrimp salad problem is a very difficult problem, I think. I think we all should devote more effort to address the questions it raises. Thank you.
So we have time for Q&A, and there's no shrimp salad in the break. So I hate to break things. Yeah. Why don't you say who you are, and so we get to know one another. I think you need to press your button.
Okay, now it is.
Thank you.
Sorry. And so my question is about wrinkle number 3 in Roberto's shrimp salad analogy. And I guess the point here is that directors are managing artificial entity that has perpetual existence. And so as we discussed in previous panels, they have to think about the long term and not just about this moment, eating a shrimp salad or not. So the motivation could be that they anticipate that in the long term, they will stop having the privilege of eating the shrimp salad, or in the long term, they will have a duty to finish the shrimp salad now. So maybe it's better for them to eat it now, like very peacefully and with good sides or whatever. So that could be your wrinkle number 3, changing the analogy. What is the motivation for doing it?
Does this work?
Yeah. So this is a long-standing debate. Actually, in a current project that inspired this shrimpy presentation. I argue that the very seminal debate, the famous Burley and Dodd debate on corporate purpose, was precisely a disagreement on the psychology and sociology of managerial power. So Dodd thought that the cultural forces in society in the early 20th century were strong enough to motivate corporate leaders to, with sufficient freedom to do that, with sufficient privilege, Hoffman would say, to make the socially desirable choice. Whereas Burley, who was more of a New Deal realist, thought that we should entrust managers to do the right thing, and more power, Hoffman would say more privilege to eat the salads, would simply serve their self-interest, will give them the tools. So I don't have a solution to that, but I think it's an empirical question, and it's not just a legal or even economic question, it's a sociological question. And it depends on norms in a certain society, it depends on how we expect the cultural factors to pressure managers to do this or that choice. By the way, Milton Friedman agreed with Dodd in the sense that he thought that corporate leaders left with enough power would make leftist choices. But since he had very different politics than Dodd, his policy solution was the opposite. But his sociological premise was the same. Was he right? Was he wrong? Were they right? But that's a question we should talk more about.
A comment here, and notice, I mean, we can see it in front of our eyes. So basically, part of what I think increased the appetite for shrimp, as it were, was a consensus among elites that the climate change issue was a serious one and it required their attention. And, you know, bodies such as the World Economic Forum fostered that elite consensus about this. In a sense, what you might think of, what the BlackRock folks were doing is telling sort of the high sign of how elites ought to behave. And the interesting thing right now is to see that we're having a cascade in just the reverse, promoted by, a different sense of what elite consensus ought to be. But anyway, all right. So Eric Orts.
Yeah, hi. Well, this is a question that combines a shrimp question with something that Jeff said about how we think about whether this is compulsion or opportunity. So one of the ways in which you define the duty, I think raises the question that we've been talking about here in a number of different ways. And that is whether the duty is, in your terms, maximization of share value, and that generally means financial value. And I think the whole question in the conference, and one that Jeff raises also when he says, well, it's an opportunity. I don't think that one way to interpret what Jeff said is that it's not, it's an opportunity, but it's not a privilege. So I think one different way to think about that is that the consensus developing is that it's a duty to take the climate seriously because the elite opinions are changing. And I don't know, we can't ask Milton Friedman today, but Milton Friedman said that even though he thought profits should be a focus, I don't think you don't see the word maximize in there. And in fact, he said within the limits of law and ethics. And ethics, at least, I think he had a very minimal idea of ethics, but he at least meant, what do other CEOs think? What do maybe if they're going to Davos, et cetera. And so if we consider that the ethics of climate is becoming an imperative, then it seems to me it becomes a duty to the same extent, or maybe at least to some partial extent, similar to profits.
Okay.
Yeah, go ahead.
One thing I just want to suggest is like one way to think about the constraint, and I just want to go back to what Brad Lander said this morning, because he's the only person who's been in the room so far who had the actual responsibility of investing $300 billion. And what he said was that he really cared about these systems, and the climate system, social systems, other environmental systems, and the impact companies were having on those systems, because he needed to manage those systems in order to manage his portfolio. So I think the constraint, on the appetite, or the impetus behind the appetite, we ought to at least look to reasonable shareholders who are asking for those things. And I'll just say that, unfortunately, we have a system where even if you understand that intellectually, it's sometimes hard to execute because of like game theory, prisoner's dilemma, free rider type problems. But I think what we ought to think about is corporate law, fiduciary law at the investment level as tools to overcome those game theory problems.
Let me ask about a question, a litigation point in the McRitchie case. So the externalities that you identified in that case were not tightly linked to the economic well-being of the portfolio investors, right? I mean, whether teenage girls are bombarded with these things, or the disinformation, there was I wondered about the lack of an allegation about the distinct economic connection between those things, which are externalities perhaps, but it's not clear how they're going to damage the portfolio of diversified investor. And furthermore, you notably did not focus on systemic risk, where you might say the diversifieds have a comparative advantage in understanding this as opposed to an individual CEO. So there's a way in which Lander, speaking today, spoke specifically the risk he was trying to manage was the systemic risk, which is distinctive from the kind of risks that you seem to identify in the case. And I wonder if you could speak to that choice, and also whether that opens space for another litigation that would address a different sort of risk that own firm activities might generate.
So first I'll say that we did try to make the case that, obviously climate is a quintessential systemic risk. It would be easy to make the case. We're a nonprofit. We have to find lawyers to argue for us. We have to find plaintiffs. We have to find funds to fund the litigation. But we thought we were able to make a pretty good case connecting some of the damage that was identified strongly in the Facebook whistleblower papers to economic literature that said these things have an impact on GDP. But you are correct. If people are interested in helping us put together some litigation on this issue around climate, maybe in New Jersey, a different jurisdiction, New Jersey, where I know that at least one oil major is located, we'd be happy to work on that.
You would have needed like a controlled oil company, which is not there, at least in the US, which have been probably more salient in terms of portfolio.
Wouldn't have to be controlled, but yeah, I mean.
Well, but for that, conflict argument.
I think it would be more like GM or Ford, which had a choice between EVs and
Right,
not
right,
EVs.
right.
Basic, I mean,
That's
that
a
would
good
be an oil, right? I think we have room for one more question. Anybody? Yeah, go ahead.
This is more a response than a question to Roberto's question about or encouragement to do the empirical research. So a very hard empirical research problem, but we already have anecdotal evidence of what might be some circumstances. So who in fact are making tens to hundreds of millions of dollar investments in clean energy? Well, firms that have clear control, sometimes dual class control, sometimes founder control, that are in high technology, that may be worried that if they start spending enormous sums on electricity to run their artificial intelligence language models or, additional social media, et cetera, they may lose social license. So I think to some extent, maybe social license is the answer to your question, that there's a pursuit of social license to continue operating. And when that requires eating the shrimp salad, then they'll eat the shrimp salad in order to retain the social license. That's just an anecdotal response, but.
Final point.
I think we should look at incentives, though, a little more directly. I mean, I do not, I take the Lynn Dallas point of view that stock-based incentive compensation for executives and for the board has done nothing more than inflame their self-interest. And we have situations now where 100% of the profits of companies goes back to stock buybacks, which, guess what, parenthetically increases the stock price for the executives, who then exercise their options. So I don't think that the sociological incentives and the incentive that the business judgment rule, the discretion the business judgment rule gives companies is going to be strong enough unless we actually look at the fact that we have overcompensated in aligning and so-called aligning incentives.
Okay, on that concerning note, we'll
Just a-
turn.
May I
take
make
what,
a
10-minute
follow-up?
break, Martin?
There is a paper.
Do we have a break? All right,
Connected.
so like a 10-minute.
There is a paper connected with Cindy argument from finance professors from the Warwick Business Schools. The paper is called Beyond ESG, Executive Pay Metrics and Shareholder Support. And what they found, which is very interesting, is that the amount of ESG metrics on CEO compensation is actually reducing the shareholder proposals against the CEOs. But so basically, they find that there is no effect on basically affecting the performance, the stock performance of the companies, quite the opposite. But also that, it seems that the mechanism for this or the incentive is to reduce actually shareholder proposals against them in terms of climate change. So it's a very interesting paper actually coming out.
Okay, so a 10-minute break and then we return for panel 4.